Advocate Sri Prashanth Bhushan. This resolution was proposed by Indian Association of Lawyers, and the first signatory to the proposal is Advocate P.A. Aziz, the former president of the Indian Association of Lawyers. We are happy that we could contribute our part. Let me officially welcome our guests and speakers. We have here several personalities from different walks of life whose voices the society listen attentively. Sri Binoy Vishwam, MP, is presiding over the webinar. He is the strong and uncompromising voice of the Communist Party of India in the Rajya Sabha. His political career spreads across a span of time, starting from his school days. He has held several coveted offices. He has been the Vice President of World Federation of Democratic Youth, WFDY. Also, he has been honored with several prestigious awards. For and on behalf of the Indian Association of Lawyers, Kerala State Committee, I welcome you, my dear comrades. The subject presentation is by Advocate Sri Prashanth Bhushan, our chief guest. As I said earlier, he is holding his head high. I welcome, for and on behalf of the Indian Association of Lawyers, Kerala State Committee, I welcome you, sir. Advocate C.B. Swaminathan is the Secretary of IAL Kerala State Committee. His works as such are laudable. I welcome my colleague and close associate Advocate C.B. Swaminathan. And all the participants, you have my hearty welcome. Welcome all. Thank you all.
My dear friends, I am quite sure that in such a meeting, the role of the president is very, very limited, because this webinar, organized by the Kerala unit of the Indian Association of Lawyers, is mainly organized to extend our support to the valiant fighter, Advocate Prashanth Bhushan, and to tell him, not as a person, but as a brave, valiant hero of the Indian judicial system, who has undertaken a very righteous struggle path to uphold the values of the Indian judicial, to tell him that we, the legal fraternity of Kerala, stand with him with all strength and vigor, uncompromising, and never can be on our knees on this great battle. This is the main purpose of this webinar, I understand, and we all understand. I feel proud, though not a practicing lawyer, but as a lawyer technically, and as a member technically too of the IAL, that the IAL took the initiative to have such a webinar today in Kerala. And the resolution which was mentioned here by Honorable Jayachandran is worth mentioning. The Kerala Bar Council is the first bar council of the whole country to come out with such a very, very clear-cut position on this legal matter. The legal matter, it's a moral matter, it's a political matter, it's a matter which is very much concerned with the pride of this nation, I should say. And this fraternity of the lawyers in Kerala, they showed their maturity as legally conscious people to stand with the values for which Prashanth Bhushan ji has undertaken a valiant battle, a valiant struggle. I salute him on behalf of all of us, and I'm thankful to him that the moment we requested him to attend this webinar as a fighter for the people's cause, as a fighter for human rights, as a fighter for democratic values, he agreed to share his views and positions on this matter with us. And that's how today he is here for this webinar. I was just going through some documents yesterday where I could see one important case in which none other than Dr. Ambedkar argued in the British courts, and he was arguing for a communist who was a member and leader of the Communist Party of Great Britain, Mr. Philip Pratt, arguing that court, Ambedkar was mentioning some of the basic features and positions the judiciary has to uphold. The case was regarding a pamphlet written by British Communist Party leadership on India's freedom struggle, mentioning the struggle of the people in India and China and condemning the positions of the British imperialism. And the arguments raised by Ambedkar was this: that resolution for which Phyllis Pratt was made a culprit by the British imperialists, Ambedkar told that pamphlet and the contents was not against the British government, it is against the British imperialism, not against the British people, but British imperialist masters. And he emphatically explained imperialism and the people are different. Imperialism and the government are different. So there is no point in making the communist leader Philip Pratt as a man who has done a mistake. This was the argument. And he later also, on many occasions, mentioned that a judge is a human being. A human being he is. A judge is not free from all errors. There is a possibility, even for the Chief Justice. Ambedkar mentioned, Chief Justice is a man with all the failings of any human beings. This he mentioned in 1949, 24th of May, in a debate in the Constituent Assembly. It's a statement that can be remembered at this occasion. So this is the history of India. And now what happened here? The Chief Justice of India, seen on a bicycle, motorcycle, worth of 50 lakhs of rupees, owned by a rich man who is also a political heavyweight. And during this pandemic days, without even a mask, where there was a crowd, not a big crowd, but more than 2, 3, 4 people are there witnessing it. For such an occasion, a Chief Justice of the country on a motorbike, with a costly motorbike, without this thing, is an insult to the whole nation, and that's what he felt. Prashant Bhushan, with all his honesty to the nation, to the people, tweeted that, and they found that this tweet was an insult to the judiciary. And the contempt of court acts do not prove that they are right. And that 1 rupee that he paid. No? No? Any problem? Ami?
Yes, nothing. Nothing. To proceed.
That 1 rupee that Prashant Bhushan paid, and that 1 rupee has a big meaning. That 1 rupee is not 100 pies. That 1 rupee upholds whatever values India stands for. And that 1 rupee is not the cost of freedom of speech. It is the cost of India's dignity and validity, and it has legal sense of justice and injustice. So this fight is a continuous fight. That's what he has stated. I remember one sentence which I should mention here before concluding. That's a small quotation from the Communist Manifesto itself. In the Communist Manifesto, it is written very clearly about the system of the capitalists. It goes like this: the bourgeoisie has stripped off its halo, every occupation hitherto on it, and looked up to with reverent awe. It has converted the physician, the lawyer, the jurist, the priest, the poet, the man of science, all into its paid wage laborers, including the lawyer, the jurist, all are becoming the paid wage laborers of the bourgeoisie in a bourgeois system. And now, in the age of globalization, we see it in the Indian courts also, which is very painful. And that pained Prashant Bhushan. And that pain compelled him, as a true Democrat, as a human rights fighter, to treat his feelings and expressions with all his honesty. With all honesty, he treated it. And for that, they are telling that it is the contempt of courts. If this is the contempt of courts, the country should now demand, it's high time to repeal this Contempt of Court Act 1971, because it is not to safeguard the dignity and the glory of the judiciary. It has come to serve the very narrow-minded interests of certain individuals who believe that a costly motorbike is an attraction. Forgetting the mask is a greatness for a jurist, and such kind of people should feel that law is not meant for them, acts are not meant for them, to interpret them as they like. Any law, any act should be powerful and meaningful only when it reflects the people's sentiments, the country's sentiments. The moment it begins to forget the people and the country's honor, law will become futile, it will become weak in itself. So Prashant Bhushan is saying that it cannot be allowed. Constitution should be upheld. Law should be with all its dignity, and the glory of the system of Indian jurisprudence has to be protected by all means. And for that, this struggle has to continue. And Prashant Bhushan has become an epitome of this struggle, in which we are all co-fighters. So with that fighting sentiment, with that feeling of oneness, I salute Prashant Bhushan ji once again from all our hearts. With these words, I conclude. We will fight, we will go forwards. Thank you all. Prashant Bhushan ji, salutes.
Yes, thank you. Thank you. You want me to make my address now?
Yeah, now you can start.
Okay. So good evening, friends and fellow lawyers from Kerala and from the Indian Association of People's Lawyers, from the Kerala Bar Association, Kerala Bar Council. First, I want to express my gratitude to the Bar Council and the Bar Association, Kerala Bar Council and the Kerala Bar Association, for having supported me and passed resolutions in my favor on this contempt matter. I'm very grateful for all the kind words that were said about me. I don't think I'm worthy of all the things that were said about me. So before I talk about the challenges for our constitutional democracy, let me say a few words about my contempt case. So in any democracy, freedom of speech is a very, very important and critical fundamental right. And the reason is that people should be free to express themselves about what they feel is going on in the country, what they feel is happening to our institutions in the country, including the judiciary. Therefore, what I had said in my tweets, which became the subject matter of contempt, was only my free and frank views about what is happening in the judiciary at the highest place, that is in the Supreme Court. If I concentrate on my second tweet, the motorcycle tweet was only about to express my anguish at keeping the Supreme Court in lockdown because of COVID, when fundamental rights of people are being denied because of this lockdown. And at the same time, the Chief Justice is seen on a motorcycle without even a mask. But it is the second tweet, which was about the what has happened to democracy in the last 6 years and what the role of the Supreme Court has been in that, and particularly the last four Chief Justices. That is really the important tweet, in which I had said three things. I had said that when historians look back, they will find that democracy has been largely destroyed in this country in the last 6 years. And they will also note the role played by the Supreme Court, particularly the last four Chief Justices, in allowing this destruction to take place. Now, those represented my honest, bona fide views and beliefs about what has happened to this country in the last 6 years and what the role of the Supreme Court and the last four Chief Justices had been. Every citizen in a democracy should be free to express those views without any threat of being prosecuted for any criminal offense. In this case, unfortunately, the Supreme Court prosecuted me for criminal contempt, for scandalizing the court, which is a very archaic and colonial part of the Contempt of Courts Act. And they finally convicted me also, though the fine was only 1 rupee. Now, the intention of the court was to try and silence me and try and silence other people like me who wanted to express themselves freely and frankly about the functioning of the judiciary. But fortunately, because of the public outcry created by friends like you and many others, exactly the opposite effect seems to have happened. Instead of chilling this discussion about the state of the judiciary and the role of the Supreme Court in failing to protect democracy in the last 6 years, it just sharpened the debate and it brought an increased focus on what has happened to our democracy in the last 6 years, what the role of the Supreme Court has been, and in particular, what the role of the last four Chief Justices has been. If you see the kind of scrutiny that the senior judge who was heading this bench, Justice Arun Mishra, has been subjected to in the last 1 week, if you see the kind of articles that have appeared uh, across the media, assessing his judicial legacy in particular, you will understand how this case has actually had the opposite effect. So, so two things have happened. One, it has brought an increased focus on the state of India's democracy in the last 6 years. It has brought a sharpened focus on the role of the Supreme Court, and it has, in fact, stiffened the resolve of the people to speak out freely and frankly about what is happening in our country. Which brings us to the actual subject of this of my talk today. So 70 years ago, when we adopted our constitution, we founded our republic. So what did we do? We created a democracy where the people are supposed to be the real masters, and all public servants, whether elected or unelected, are supposed to be their servants who work according to their wishes. For that, We created a system of elections to protect the fairness of the elections. We created an independent election commission. But most importantly, the Constitution gave all citizens various fundamental rights. They gave us the fundamental right to equality, the various civic rights under Article 19, the freedom of speech, the freedom of practicing any profession, the freedom of assembling peacefully and expressing ourselves, the uh, various freedoms under Article 19. And the Constitution gave us the fundamental right of life and liberty, which was thereafter expansively interpreted by the Supreme Court to mean the right to live with dignity and having all those things which are necessary to live with dignity. Along with that, it created a very important institution, that is the judiciary, the higher judiciary in particular, the high courts and the Supreme Court, whose job was not merely to function as appellate courts and decide cases, but whose main job was to protect fundamental rights of the people and to ensure that the executive and the legislature remain within the bounds of the powers given to them by the Constitution to strike down any law which went against the Constitution and to strike down any executive action which went against any law or against the Constitution or which violated any fundamental rights, and also order the executive to perform their constitutional duty. So these were very important roles which the Constitution entrusted to an independent judiciary. And to ensure that the judiciary remains independent, they also ensured that the government of the day could not do anything to judges except through a process, a very difficult and cumbersome process of impeachment, which has been found to be quite impractical. We also created a constitutional and auditor general, a comptroller and auditor general, whose job was to audit all government expenditure in order to ensure that public funds are protected. So, and the directive principles were also enshrined in the Constitution, which directed the state to make laws and policies which are designed to reduce inequalities among people, which are designed to improve the condition of the poor, weak, and vulnerable, like the Dalits and the minorities. Minority protection rights were also given under the Constitution. And also the state was enjoined to inculcate scientific temper among the people. But what are we seeing today? Of course, there was an assault on our democracy during the emergency when lots of people were put in jail, fundamental rights were suspended, press censorship had been imposed. But what we are seeing today, even without the imposition of a formal emergency, is far worse than what had ever happened even during the emergency. Why do I say this? Because today we find that all our fundamental rights are under assault by the state. The right to equality has been assaulted repeatedly by trying to make laws and adopt policies and uh, and coerce the police to ensure that the minorities, Muslims and Dalits do not get equality before the law, to ensure that India becomes a Hindu Rashtra where Hindus and people from some other religion get a preferred status and Muslims are reduced to second-class citizens. There is an assault on all our Article 19 rights. particularly freedom of speech. When people say anything against the government, they are either beaten up on the streets with the police looking on as helpless bystanders, sometimes participating in the beating up of those people, particularly if they are from minority communities. And we are also seeing a lynch mob. There is a lynch mob on the streets. There is a lynch mob on the social media and even the mainstream media who abuse and threaten people on the social media, and very large parts of the mainstream media also who are now completely under the control of the government. We are also seeing cases of sedition being registered against those people who dare to speak up against the government. And now, of course, there is also the use of the Contempt of Courts Act against people like me. We are also seeing an assault on our uh, right to protest during this lockdown for the last 6 months, almost more than 5 months. We cannot go out and protest. Section 144 has been imposed across the country. All political rallies, political processions, political meetings have been banned, with the result that this is a basic democratic right under the Constitution. Even that is not being allowed today. We are also witnessing an assault on the right to life and liberty, in as much as a large number of people, laws, draconian laws like the UAPA are being used to arrest, harass, intimidate, and victimize some of the finest activists in the country, whether they are for the Bhima Koregaon, in the guise of the Bhima Koregaon protest, where absurd charges have been leveled against some of our finest human rights defenders like Sudha Bharadwaj, Anand Teltumble, Varavara Rao, etc., and including against all those people, activists who helped the anti-CAA protests which took place against a law which is totally discriminatory. The CAA law is clearly discriminatory. Petitions have been filed in the Supreme Court challenging it, but unfortunately the Supreme Court is not doing anything. Uh, so simultaneously, we are seeing an assault on our scientific temper. Instead of trying to improve the scientific temper among people, the government is trying to destroy not just scientific temper, but even critical thinking. There is a whole-scale assault on universities. Vice chancellors have been appointed to universities whose only qualification is that they have belonged to the RSS or that they owe allegiance to the BJP, who have no idea of education, who keep saying that we will install tanks in universities, who have banned political discussions inside universities, etc. There is a whole-scale assault on critical thinking. Scientific temper is being eroded by propagating all kinds of nonsense. The Prime Minister himself goes to inaugurate the Ambani Hospital and says that Lord Ganesha's trunk was stitched on by a piece of plastic surgery which was practiced in ancient India. The Prime Minister tells children that there is no such thing as climate change and we are feeling the heat only because we are becoming old. I mean, every kind of his ministers are propagating that if you say go Corona, go, that Corona will go away, or some papad, eating some papad whose brand is being promoted will make Corona go away. And there is a whole scale assault on every institution which was created to protect democracy. There is an assault on the independence of the judiciary. I'll come to the judiciary in a minute. But there is an assault on the election commission. There is an assault on the controller and auditor general. For the last 35 years, we have seen an independent election commission. It is only in the last few years that people have started raising questions about the independence of the election commission. People are being appointed as election commissioners who have no qualification to being there. The chief election commissioner, this fellow Sunil Arora, he is caught in the Radia tapes discussing with Meera Radia how he knows a person who has bribed the Chief Justice of the Punjab and Haryana High Court to procure a judgment by paying him 9 crores. And that fellow has been appointed as the Chief Election Commissioner, who is deciding election dates on the convenience of the ruling party and the Prime Minister and not independently, who is not preventing the Prime Minister and Mr. Amit Shah and the BJP leaders from violating the model code of conduct, who is not preventing the violation, whole-scale violation of the election spending laws, where parties and candidates are overspending amounts by 10 times, 100 times of the limit, etc. Elections have been reduced to a money game. There was, you see, today, unfortunately, the kind of democracy that we adopted was representative democracy, where we elect our representatives and thereafter the representatives thereafter rule on our behalf or make policies and laws and implement them on our behalf. Now, in this representational democracy, there is first past the post at 2 levels. First level is when we elect our representative, the person who gets the highest votes gets elected, even if all the rest of the candidates put together have got 4 times the number of votes secured by the highest candidate. So all the others count for nothing. He becomes the sole representative. Thereafter, when the government is formed, the party or the coalition which has 51% of the seats, they get to form the government, and the rest of the opposition count for nothing in the government. So when people go out to vote, they are voting not necessarily for the candidate or the party that they consider the best. They then see, because they know that if this candidate or party has no chance of winning, then their vote will get wasted. So then they see which is the party or the candidate which have some chance of winning, and they choose the least bad from among those. Now, how do they assess which candidate or party has any chance of winning? That assessment is made on the basis of the visibility of that candidate or the party. And that visibility is usually a function of money, which means if you have money, you can make yourself very visible by having a lot of advertisements in newspapers and the electronic media, by putting up a lot of boards, by having a lot of posts, by organizing large rallies, by paying people to bring in crowds, etc. And of course, if you have the media in your control, then you can certainly increase your visibility. So there is a heavy advantage accruing in this system to those parties with a lot of money, and particularly the ruling party, which not only has a lot of money, but also has a large control over the media by misusing. You see, today, this government, one of the very, very unfortunate things that has happened is that we have a media which is totally under the control of the government to a very large extent. The mainstream media has come under the control of the government, with the result that instead of doing what they ought to be doing, that is providing people with the correct information, that is providing people with discussions on relevant issues, we have a media which is trying to spread misinformation, false information, hateful information, not even information, hateful fake news, in order to create a communal divide among people in this country, and in order to divert attention of the people from real issues. For the last 2.5 months, we have been seeing a large number of TV channels just going on about this Sushant Singh Rajput's death, as if that's the most important issue in the country. And in the process, spreading all kinds of nonsense and fake news, etc., just in order to paint that girl Riya Chakrabarti as a criminal, etc. So, so that when that happens, and there is an attempt, therefore, to make the people lose the ability to distinguish between what is true, what is false, what are real issues and what are bogus issues, etc. And that is why I say that there is a concerted assault on critical thinking. There is a concerted assault on scientific temper. And all this is being done not just by the government, but also through the media, which is controlled by the government. So this is the situation of, and therefore, what we needed was reforms in the election law to place limits. You see, there is a theoretical limit on the election spending by individual candidates, but there is no limit on the spending of political parties, with the result that ruling parties, particularly this ruling party, can spend 50 times the amount that any single candidate is allowed to spend, or all their candidates put together are allowed to spend, just by saying that these are party funds being spent and not the funds of the candidate. So we needed to have a law to check the expenditure of political parties. That was not brought. We needed to have, when the Prime Minister brought this demonetization, he said that this is to make the economy cashless. Now, you can't make the whole economy cashless, but you could have certainly made political parties become cashless by making a law saying that at least political parties and candidates will not be able to spend money by cash. Everything will have to be through bank transactions. That would have allowed the Election Commission to closely monitor the income and expenditure of candidates and political parties. But that was not done. And instead of that, three very retrograde changes were brought in the laws relating to political funding. First, they said introduced electoral bonds, which is a totally non-transparent way and allows people to funnel bribes and black money to political parties anonymously. Then they changed the law which limited the donations which can be made by corporations to political parties. The earlier limit was 7.5% of annual profits. That limit was eliminated so that now you can give unlimited money to political parties, corporations can. Thirdly, the Foreign Contribution Regulation Act was mainly brought to check and prevent foreign contributions to political parties. They removed that also and allowed political parties to take foreign contributions through Indian subsidiaries of foreign companies registered in India. So therefore, they did exactly the opposite of what was required to be done, thereby making this whole business of electoral politics even more a game of money. Then the Comptroller and Auditor General. That institution was also regarded to be an independent constitutional authority, which was to audit government expenditure independently of the government. But today, for the first time, we are seeing a CAG which has dropped the pricing details of the Rafale deal just because the government did not want the CAG to give the pricing details in their audit of the Rafale contract. This has never happened before. First time in the history of the CAG, pricing details have been dropped from the audit of a defense deal. Secondly, they have dropped the audit of the offset contracts of the Rafale deal, only because the offset contracts had been given to this bogus company of Anil Ambani. At the instance of the government, that has been dropped. So even the CAG's independence has been destroyed. But the most serious assault has taken place on the judiciary. As I said in my reply to the contempt notice, once when they gave me a contempt notice for my tweet where I had said that when historians look back to see how democracy has been destroyed in the last 6 years, they will particularly note the role of the Supreme Court and the last 4 Chief Justices. So when a contempt notice was sent to me, I sent a very detailed reply, 140-page reply, in which I detailed why I believed and why I believe that democracy has been substantially destroyed in this country in the last 6 years, in which I detailed all these things. And I also detailed why I believe that the Supreme Court has not fulfilled its role or its responsibility to protect democracy, to protect fundamental rights, and to check the executive power. And I pointed out how many cases they have just not heard. For more than 1 year, the challenge to the change of status of Kashmir from state to a union territory, the removal of Article 370, the lockdown in Kashmir, the habeas corpus petitions are not being heard. uh, for almost 9 months now, more than 9-10 months, the challenges to the Citizenship Amendment Act are not being heard. Uh, so there is inaction, and wherever there is action also, for example, in Ayodhya, the same people who were found to have demolished the mosque in a criminal conspiracy and who are being prosecuted for that, they have been given charge of that land to build the mosque. In the Birla Sahara case, the court says that even though the income tax department had recovered documents showing the payment of more than 40 crores by Sahara to Mr. Modi, 25 crores by Birla to Mr. Modi, that need not be investigated because they say that big people, powerful people need not be investigated on the basis of loose papers. These loose papers are recovered from these companies. They are not even loose papers, they are the computer records. You are prosecuting the Bhima Koregaon people on the basis of fabricated computer records, and these are computer records which the income tax department, etc., itself saying were recovered from Birla and Sahara from their computers, which show payment of huge amounts of cash to these politicians as bribes, etc. But you are saying that this need not be investigated. Same thing they did about that Harin Pandya murder case, when there was overwhelming evidence to show that Harin Pandya could not have been murdered in the way that the Gujarat police was making out to be, and that there was much more than meets the eye, and therefore it required a detailed investigation. He was the minister in the Modi government who had deposed before this independent people's tribunal headed by Justice Krishna Iyer that the Modi government had indeed uh, fanned or rather encouraged that carnage to take place in Gujarat in 2002. And that minister of his own government was thereafter murdered in very suspicious circumstances. And yet that was not allowed in that Judge Loya case, where there were so many suspicious circumstances. He was the judge who was trying Mr. Amit Shah and some police officers for multiple uh, fake encounters, which were called encounters, but which were obviously fake. That judge suddenly, very mysteriously dies. There were so many circumstances suggesting that the official story was not correct, but that case is allowed to be closed or no investigation is ordered just because the government gives the court something in a sealed cover, which is not even shown to the other side. And on the basis of some bogus information given in a sealed cover, the court closes the case. Same thing happened in the Rafale case on the basis of a totally bogus sealed cover note, which is not even attested by any affidavit of anybody, not shown to the opposite parties. On that basis, the court says that there is no need for any investigation in this matter. So in case after case, we have seen that the Supreme Court has failed to protect, failed to order investigations for murders, for very important suspicious murders, for in very important cases involving corruption in high places, etc. And in almost every case in this post-mortem of Justice Arun Mishra's tenure as the Supreme Court judge, it has been pointed out by many commentators that so many important, critical, politically sensitive cases were just given to him by successive chief justices. And that is why those 4 judges held a press conference, unprecedented press conference, when the Loya case was given to him. So again and again, we are seeing, uh, uh, and in Justice Mishra's case, it has been pointed out that in virtually every politically sensitive case, he went in accordance with what the government wanted. And here was a judge who had invited the BJP leaders to his residence for his nephew's wedding at a time when this Birla Sahara case was pending before him. And one of the persons who was invited, whose photograph was published, was Mr. Shivraj Singh, who is said to have received 10 crores according to the Sahara diary, which was recovered. And that was a case pending before him. The code of conduct of judges says that judges should not hobnob with politicians. Now, the only reason why you can depart from that rule is if a politician happens to be a close personal friend of yours. Now, if you have invited Shivraj Singh to your residence because he is your close personal friend, then another part of the code of conduct says that you should not be hearing his cases. But Justice Arun Mishra continued to hear his case, continued to decide that case, and said that there is no need for any investigation. Now, we need to examine as to why the independence of the judiciary has collapsed in the last few years. What has happened? Of course, one of the things that we have seen is the lure of post-retirement jobs. Justice Sathashivam, who was the Chief Justice, was given a governorship. Justice this Ranjan Gogoi was given a Rajya Sabha membership. Now we need to see what this Justice Arun Mishra is going to be given. So many people, so many judges get lured by post-retirement jobs. But we are seeing something more serious than this. You see, this government is known to have used the investigative agencies like CBI, Enforcement Directorate, IB, income tax, etc., in order to harass and intimidate opposition leaders, in order to bring the media, the independent media, in line with the government, like they have done with NDTV, in order to sometimes even coerce businessmen. So, for example, this GVK, this Mumbai airport, so there were some CBI raids against this GVK group, and immediately thereafter, they entered into a collaboration, or they sold that airport to the Adani group, which is the government's favorite company. So, there is a feeling that the agencies have also been used against judges in order to bring them online. So therefore, this is a very serious matter, and we need to therefore now sit down, think it through, and launch a campaign to reclaim our republic. Our republic is under serious threat. Everything that we value is under serious threat. Every institution created to protect democracy is under serious threat. All our fundamental rights are under serious threat. And therefore, it is for us now to think it through as to what are our priorities. But there are so many things that need to be done. We need to have a campaign for the right to employment. Today, there is a GDP has gone down by 24%. Crores, tens of crores of people have lost their jobs. Why should there not be a right to employment? Why should the Narega kind of scheme not be extended to the whole country, to every adult, so that every adult in the country is ensured at least 180 days of work at least minimum wages? If the right to live with dignity is a fundamental right, right to employment at least minimum wages for at least 180 days in a year is also a fundamental right. We need to launch a movement for that. We need to launch a movement for judicial reforms to ensure that we have proper judges being appointed, independent judges being appointed, because in the judiciary today, there is a huge problem about judicial appointments. There is no system which has been put in place for ensuring that judges who are appointed have values that match with the constitutional values. Recently, Justice Arun Mishra's younger brother has been appointed a judge of the Madhya Pradesh High Court. And if you look at his social media posts, he is totally communal. He does not subscribe to the values of the Constitution. But this is an aspect which is not even examined in our present system. We need to have an independent judicial appointments commission which examines the credentials of the potential candidates who are to be appointed judges by examining them across a range of values that are or qualities that are important for a judge. Today, if you ask a Chief Justice, how do you select anybody as a judge? They will say, well, we look at competence and we look at integrity. The question is, why do you not look at other qualities like judicial temperament, whether this man adheres to the Constitution or not, whether he has any understanding of and sensitivity about the common people of this country or not? These are also important qualities which are required in a judge. And how do you judge how competent a candidate is? They will say we look at their judgments, but there are no judgments for lawyers who are appointed as high court judges, etc. How do you judge the integrity of a person? They will say we ask for the IB report. IB is not a proper agency to judge the integrity of any person. The IB is known to give all kinds of bogus and false reports, etc. So therefore, we need to have a proper judicial appointments commission, which should be a full-time independent body, independent of the government, totally independent of the government, and which should lay down a criteria for selection of judges, lay down a method for judging people on that criteria, and do its job in a proper, transparent manner. Today, there is no transparency in appointments. Nobody knows that Justice Arun Mishra's brother is going to be appointed. If people had known that, they would have pointed out that this man is totally communal. He does not adhere to the values of the Constitution. But unfortunately, nothing of that is done. Secondly, we need to have a judicial complaints commission to examine complaints against judges to ensure accountability of judges. Today, this impeachment process is a totally impractical process. We need to replace it by a system by which we have an independent authority, independent of the government, independent of the judiciary itself, which examines complaints against judges, has an investigative machinery under their control, and thereafter, if required, holds a trial of the judge, and thereafter orders whatever action needs to be taken against him. So we need a movement and a campaign for judicial reforms. There are so many. We need a movement and campaign for electoral reforms. We need to have some form of proportional representation. We need to reduce the role of money, power in elections, etc. We need to run a campaign for agriculture reforms. All those things required to be done. And especially for the judiciary, it is lawyers like all of you who need to be at the forefront of this campaign for judicial reforms. Of course, the main stakeholders for judicial reforms are the consumers of justice, the people who need a functional judiciary for getting justice, they have to come forward. The people have to come forward, but at the cutting edge of this campaign have to be lawyers who understand the system. So I would just end with these words that today our republic is under an unprecedented threat. Everything that we value is at stake. We have to make an extraordinary effort to reclaim our republic, but we have to make that effort, because if we do not, then we lose everything. All of us will lose, and this country will be destroyed. Our republic will be in tatters. Thank you very much.
So thank you very much, Prashant Bhushan ji. Now, what do you think? Do you have the time to respond to one or two questions? Yes.
Just one or two questions. That's all.
Yeah. Then 2 questions.
Yeah.
First come, first ask. The floor is open to the advocates or democratic-minded people or whoever is here listen to him. They can ask their questions to him. Only 2 questions are possible to ask all together. Unmute that person. The lawyer comrade who is now doing the technical part should unmute that request for 2 questions. Unmute them. Swaminathan.
I think we can skip the questions this time.
Yes. Yeah, then,
Let it be.
okay.
Let it be.
So we are skipping it.
Yeah.
Then
So can I
Swaminathan.
leave? Can I
No,
leave?
only 2 minutes more. 2 minutes more, please.
All right. Okay.
Secretary of the IAL State Committee, Advocate Swaminathan, will register the vote of thanks.
Swaminathan's net problem, so the vote of thanks will be delivered by Advocate Balakrishnan from Malappuram.
Okay, then do it.
Balakrishnan. Balakrishnan.
Forget it then, Jachandran. You
unmute ചെയ്താ മതി. Balakrishna. Mohandas available ആണോ? Mohandas. 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 Mohandas.
then we can conclude.
Okay.
Jachandran will express the vote of thanks.
1 minute. Indira Ravindran available. ഒന്ന് unmute ചെയ്താ മതി.
So Indira Ravindran, you are free there?
Net problem ആണെന്ന് തോന്നുന്നു കേട്ടോ.
It's all right. It's all right. Don't have to get into this formality.
Yes, sir. Thank you very much. Thank you very much for your kind participation and for your kind words. Thank you for and on behalf of the Indian Association of Lawyers, Kerala State Committee. Thank you very much. Thank you very much, sir.
The words were kind, not only kind, they were with a vision.
Yeah.
And those words were really urging the people, the lawyers, to understand the situation around us and to go forward.
As I told earlier, his head is high.
So
Yeah.
So we conclude the meeting. We are all thankful to Prashant Bhushan.
Thank you very much. Thank you.
ഈ പരിപാടിയിൽ പങ്കെടുത്ത IAL-ന്റെയും മറ്റ് സംഘടനകളുടെയും മറ്റ് എല്ലാ വിഭാഗം ആളുകളും പങ്കെടുത്തിട്ടുണ്ട്. സാമൂഹ്യ പ്രവർത്തകരുണ്ട്, സാംസ്കാരിക പ്രവർത്തകരുണ്ട്, കലാകാരന്മാരുണ്ട്, കലാകാരികളുണ്ട്, അഭിഭാഷക സഹോദരന്മാരും അഭിഭാഷക സഹോദരിമാരുമുണ്ട്, ഇന്ത്യൻ അസോസിയേഷൻ ഓഫ് ലോയേഴ്സിന്റെ നേതാക്കന്മാരുണ്ട്, എല്ലാ ജില്ലകളിലെയും സംസ്ഥാന നേതാക്കന്മാരുണ്ട്. എല്ലാവർക്കും ഇതുപോലൊരു പരിപാടി ഏകദേശം 900-ൽ പരം ആളുകൾ പങ്കെടുത്ത ഈ വെബിനാർ ഇന്ത്യൻ അസോസിയേഷൻ ഓഫ് ലോയേഴ്സിന്റെ ഈ കമ്മിറ്റിയുടെ നേതൃത്വത്തിൽ ഇങ്ങനെ ഒരു പരിപാടി കാലിക പ്രാധാന്യമുള്ള ഒരു വിഷയം ഏറ്റെടുത്തുകൊണ്ട് നടത്തിയ ഈ വെബിനാർ, ഇത് പ്രശാന്ത് ഭൂഷൺ അദ്ദേഹത്തെ ഈ പരിപാടിയിൽ പങ്കെടുക്കാം എന്ന് സമ്മതിച്ചപ്പോൾ ബിനോയ് വിശ്വം സഖാവ് എന്നോട് ചോദിച്ചത് ഒരു ചലഞ്ച് ഏറ്റെടുക്കാമോ എന്നാണ് ചോദിച്ചത്. ആ ചലഞ്ച് നമ്മൾ ഏറ്റെടുത്തു. വളരെ ഗംഭീരമായി ഈ പരിപാടികൾ സംഘടിപ്പിച്ച ഇന്ത്യൻ അസോസിയേഷൻ ഓഫ് ലോയേഴ്സിന്റെ എല്ലാ ജില്ലാ കമ്മിറ്റികൾക്കും, എല്ലാ ജില്ലാ ഭാരവാഹികൾക്കും, സംസ്ഥാന നേതാക്കന്മാർക്കും, ഓരോരോ പ്രവർത്തകർക്കും IAL സംസ്ഥാന കമ്മിറ്റിയുടെ പേരിൽ നന്ദി രേഖപ്പെടുത്തുന്നു. നന്ദി രേഖപ്പെടുത്തേണ്ട നമ്മുടെ സ്വാമിനാഥൻ ജനറൽ സെക്രട്ടറിയാണ്. എന്നെ ഫോണിൽ വിളിച്ചിരുന്നു, അവിടെ നെറ്റ് പ്രോബ്ലമായി, അതുകൊണ്ട് കഴിയുന്നില്ല. അപ്പൊ എല്ലാവർക്കും ഒരിക്കൽ കൂടി നന്ദി രേഖപ്പെടുത്തുന്നു. ഔദ്യോഗികമായി ഈ വെബിനാർ അവസാനിപ്പിക്കുവാൻ അധ്യക്ഷനോട് അഭ്യർത്ഥിക്കുന്നു.
അപ്പോൾ നമ്മൾ എല്ലാവരും കേട്ട, എല്ലാവരും കൂടി വിജയിപ്പിച്ച, എല്ലാവരും കൂടി ഭാവിയിൽ തുടരാൻ പോകുന്ന ഒരു വലിയ സമര തീരുമാനവുമായി ജുഡീഷ്യറിയുടെ ജനാധിപത്യ മൂല്യങ്ങളുടെ എല്ലാം താല്പര്യങ്ങളും ഉയർത്തിപ്പിടിക്കാൻ വേണ്ടിയുള്ള സമരങ്ങളിൽ മുമ്പോട്ട് പോകാൻ നമ്മളെല്ലാം പ്രതിജ്ഞാബദ്ധരാണെന്ന് പറഞ്ഞുകൊണ്ട് ഈ വെബിനാർ ഇവിടെ അവസാനിക്കുന്നു. നമസ്കാരം.
ബിനോയ് വിശ്വത്തിനും നന്ദി, ബിനോയ്ക്കും നന്ദി, നമ്മുടെ കുടുംബത്തിലെ അംഗം.
IAL കൊല്ലം യൂണിറ്റിന്റെ യൂട്യൂബ് ചാനലിൽ ഈ വീഡിയോ അവൈലബിൾ ആണ്. ഇതിന്റെ ലിങ്ക് എല്ലാ വാട്സാപ്പ് ഗ്രൂപ്പുകളിലും ഷെയർ ചെയ്യണമെന്ന് അഭ്യർത്ഥിക്കുകയാണ്. ആ യൂട്യൂബ് ചാനൽ സബ്സ്ക്രൈബ് ചെയ്യണമെന്ന് കൂടി അഭ്യർത്ഥിക്കുന്നു. അൺമ്യൂട്ട് കൊടുക്കാൻ എങ്ങനെയാണ്? എല്ലാവരെയും അൺമ്യൂട്ട് ചെയ്യാൻ.
ഏതാണ്ട് പിന്നെ അടിച്ചു കൊടുക്കണം. കൃഷ്ണൻ വരുന്നു. ഞാനൊന്നും പറയുന്നില്ലെന്ന് തോന്നുന്നു. കേട്ടോ, ഇല്ല, വരുന്നുണ്ടോ? ചെയ്യുന്നു, വരുന്നു, ഫോൺ വരുന്നു, കണക്ഷൻ പോയതാ.
കണക്ഷൻ ഒന്നും പോയിട്ടിരുന്നല്ലോ.
കിട്ടുന്നുണ്ട്. കണക്ഷൻ ഒന്നും പോയിട്ടൊന്നും കേക്കാൻ വയ്യ, കേക്കാൻ വയ്യ. അങ്ങനെ ഞെക്കിയാ കേട്ടു. എവിടെ എന്ത് കേൾക്കാനാ? കേൾക്കുന്നുണ്ട്, പറയുന്നുണ്ടല്ലോ. കണക്ഷൻ ഒന്നും പറയുന്നില്ല. അത് തന്നെ കണക്ഷൻ കഴിഞ്ഞു ഞങ്ങളുടെ സ്പീച്ച് കഴിഞ്ഞല്ലോ. കേക്കാം, നന്നായിട്ട് കേക്കാം.
എന്ത് സംഭവിച്ചു?
കാറിലിരുന്നാണല്ലോ, നമ്മളെ കാട്ടുന്നില്ലല്ലോ. അതെ അതെ, മുമ്പ് IAL പ്രസിഡന്റ് വന്നായിരുന്നു.
സാബു
ഗംഭീര പരിപാടിയായി പോയി. എന്തായാലും
സാബു മോഹൻദാസാണ്.
വളരെ നല്ല പരിപാടി.
Unable to തന്നെ.
ഞാൻ നേരത്തെ പിരിയാണ്. ഹലോ സാർ, ഹലോ സാർ. സാർ, ആ യൂട്യൂബ് ചാനലിന്റെ പേരൊന്ന് പറയോ?
യൂണിറ്റ് IAL കൊല്ലം യൂണിറ്റ്.
IAL കൊല്ലം യൂണിറ്റ്. ഇത്
യൂട്യൂബിന് അങ്ങനെ സ്മോൾ ലെറ്റർ ഇല്ല, IAL കൊല്ലം യൂണിറ്റ് എന്ന് അടിച്ചാൽ മതി.
IAL കൊല്ലം യൂണിറ്റ്.
ചൂടായിട്ട് ഷവർമ മാത്രമേ ഉള്ളൂ. പൊറോട്ട
കഴിഞ്ഞോ? കഴിഞ്ഞോ?
ഡിവൈസ് ലൊക്കേഷൻ വിത്ത് യൂസർ
ഹലോ,
എനിക്ക് ഞാൻ തോടാ നോക്കിയുള്ളൂ. മറ്റേത് എനിക്കറിയാം, അല്ലാണ്ട് എല്ലാം ക്ലോസ് ചെയ്യാൻ അറിയാന്ന്. കഴിഞ്ഞോ? ഇതും ഇത് നേരെ പ്രിന്റ് ഉണ്ടായി കണ്ടോ വെച്ചത്.